We got a phone call, so whoever that was, thank you for calling and letting us know that you were running late. What we're going to do now is I'm going to instruct you a little bit about the law that you will follow in this case, and then we'll go right into opening statements. So, ladies and gentlemen of the jury, before we hear the opening statements of counsel and begin to take evidence, I will read to you some preliminary instructions to follow in listening to and considering the evidence which you will hear in this case. I will also give you some further instructions after you've heard all the evidence that covers additional law which you are to follow. It is my duty to instruct you in the law, and it is your duty to follow the law as I state it to you both now and at the conclusion of the trial. Over the years, which will guide us in the conduct of the trial. Generally, you may not fully understand why we have those rules, but I assure you there are good reasons for them, even if those reasons are not apparent to you. Now, during the course of the trial, an attorney may make an objection to the introduction of certain testimony. He or she, in effect, is saying that in his or her opinion, the offered testimony is not permitted by the rules of evidence. Now, whenever there's an objection that's made, I will either sustain the objection or overrule the objection. When I sustain an objection, the witness will not be permitted to answer the question. You must not guess why I have sustained the objection, and you may not speculate as to what the answer might have been. When I overrule an objection and the evidence is permitted, That does not express any opinion as to how you should treat such evidence. All that ruling says is that you have a right to hear such evidence. But you, as jurors, may completely reject such evidence. You may give it very little weight, or you may give it a great deal of weight. That is your responsibility as jurors, because you are the judges of the facts. If any answer is given to a question and the court then grants a motion to strike out the answer, you are then to completely disregard the answer, and you must not consider it for any purpose. Just treat it as though you never heard it. You should keep in mind that a question in and of itself is not evidence and may be considered by you only as it helps you to understand the answer. Do not assume to be true any insinuation suggested by a question that is asked of a witness. You must disregard anything you see or hear when a court is not in session, even if it is done or said by one of the parties or one of the witnesses. No statement, ruling, remark, or comment which I may make during the course of the trial is intended to indicate any opinion I may have as to how the jury should decide the case or to influence the jury in any way in its determination of the facts. At times, I may ask questions of the witnesses. If I do so, it's for the purpose of only bringing out matters that I feel should be clarified and not in any way to. Now, as I've told you before, you are fortunate to have some very good trial lawyers in this case. I'm just going to let them try their case. However, if I'm confused about an answer or about a location or who they're talking about, I might jump in and just clarify it, but it'll be a rare occasion when I do that. Now, as I stated earlier, the defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove each element of a crime and each element of every allegation beyond a reasonable doubt. Whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that is received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he's entitled to an acquittal, and you must find him not guilty. Now, any fact in this case may be proved by either direct or circumstantial evidence, or by a combination of both. Now, direct evidence can prove a fact by itself. Circumstantial evidence sometimes is referred to as indirect evidence. And I'm going to read you the definition of circumstantial evidence now. Keep in mind it was written by a bunch of lawyers and judges, so see if you can follow this. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may conclude the truth of the fact in question. So I hope that clears it up for you. Let me give you an example. Let's assume that the only question in this case is whether or not the defendant was swimming in a backyard swimming pool. And a witness comes in here under oath and takes the stand and testifies, "I saw the defendant in the swimming pool." Well, that's direct evidence of the ultimate fact which you are asked to decide. Now, let's say a witness comes in and says, "I didn't see the defendant in the swimming pool, but I walked into the backyard. The water was all choppy as if somebody had just been swimming. There was nobody else in the backyard, and there were wet footprints leading up to the defendant, who was standing there soaking wet in a bathing suit, dripping water all over the place." Now, those facts all constitute circumstantial evidence that the defendant was in the pool, but it does not directly prove that he was in the pool. So with that said, let me reread the definition of circumstantial evidence for you. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may conclude the truth of the fact in question. Now, both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental states and acts necessary to a conviction, and neither is necessarily more reliable than the other. You must decide whether a fact and issue has been proved based on all the evidence. Now, as jurors, you have the exclusive duty to decide the credibility of the witnesses who will testify in this case, which means that it is you who must decide whether to believe or disbelieve a particular witness and how much weight, if any, to give to the testimony of each of the witnesses. The testimony of each witness must be judged by the same standard. You must set aside any bias or prejudice you may have, including any based on the witness's gender, race, religion, or national origin. In deciding whether testimony is true and accurate, use your common sense and your experience. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and then decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony, including but not limited to the following factors: the extent of the opportunity or the ability of the witness to see or hear or otherwise perceive the things about which the witness has testified, the ability of the witness to remember or describe what happened, the witness's behavior while testifying here in court, whether the witness understood the questions and then answered them directly, the existence or non-existence of a bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in the outcome of the case, the attitude or demeanor of the witness about the case or about testifying, whether the witness made a statement in the past that is consistent or inconsistent with his or her testimony, and finally, the reasonableness of the witness's testimony when considered in light of all the other evidence in the case. Now, do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the very same event, yet see it or hear it differently. If you do not believe that a witness's testimony that he or she or no longer believes or remembers something, that testimony is inconsistent with the witness's earlier statement on that same subject as to whether or not they remembered making a prior statement. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but then told the truth about others, you may simply accept the part that you think is true and then ignore the rest. Both the people and the defendant are entitled to the individual opinion of each juror. That means that each of you, for yourself, must determine the factual issues to be resolved in this case. Some words or phrases that may be used during a trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in the instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in the instructions are to be applied using our ordinary everyday meanings. Please keep an open mind throughout the trial. Don't make up your mind about the verdict or any issue until after you've discussed the case with the other jurors during deliberations. Now, do not take anything I say or do during the course of the trial as an indication of what I think about the facts, the witnesses, or what you think your verdict should be. When we come back tomorrow, you will be given notebooks and some pens that will be on your chairs when you come in, along with a summary of the charges that will help you with the dates and the counts and Jane Doe's 1 through 5 and which Jane Doe pertains to each count. You're not going to get the notebooks today because we're just going to do opening statements today. As I told you, what the attorneys say is not evidence. So when you come in tomorrow, the notebooks will be on your seat. Please do not remove the notebooks from the courtroom. You cannot take them outside on a break, and you cannot take them home. You will be able, however, to take your jury notes into the jury room when you deliberate. You may use your notes during deliberations only to remind yourself of what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. If there is a disagreement during the trial or during deliberations about what actually happened at trial, you may ask that the court reporter read back the relevant parts of the testimony to assist you. Please do not let your note-taking distract you from your ongoing responsibility to evaluate the witnesses and the evidence. Now, just a word of caution, if you do act for readback, the court reporter has to go through the testimony and remove any objections and remove any stricken testimony, so it may take her time to prepare that. There's also a misconception that transcripts are prepared every day from the testimony, and that's not the case. The transcripts in a case like this may take months to prepare. So Sometimes I'll get a note from the jurors, can you send back all the transcripts? The answer is going to be no, because the transcripts do not exist yet. Now, I also expect that police reports will be mentioned throughout the trial, and a lot of witnesses may refer to police reports to refresh their memories to what they said at an earlier occasion. It is proper for the attorneys and the witnesses to refer to police reports during the trial. However, the written police reports themselves are not evidence for a number of legal and evidentiary reasons, and therefore you will not be receiving copies of the police reports back in the jury room during their deliberations. If it does appear to you that some reference in a police report is important to your understanding of the facts, you can just jot it down in your notes. You must not allow anything that happens outside of the courtroom to affect your decisions. During the trial, again, I'm going to remind you, do not read, listen to, or watch any news reports or commentary about this case from any source, if any. And I'm really going to ask that you be diligent in this case, because there's going to be a lot of media coverage on this case. Don't read anything in the paper. This may or may not be the lead story on the 5 o'clock news, so be very vigilant when you turn on the news. If you see anything about this case, shut it off, leave the room, and don't watch it and don't read anything. You also may have noticed when you go outside the courthouse and look to your right, there are a bunch of media tents and media trucks that are parked out there. And that's where those people I told you about last week, the mind readers, are out there, and are going to tell everybody what you're thinking and how you're taking any evidence. I'm going to order you stay away from that part of the parking lot and don't go over there and listen to anything they're saying. What's important in this case is that you make your decision on what you hear in the courtroom and not what you hear from any media source outside the scope of the trial. Do not do any research or investigate on your own at all or as a group. Do not use a dictionary or the internet. Do not Google anything about this case. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you happen to pass by one of the scenes, do not stop and investigate. If you have a cell phone, I know all of you do, or other electronic device, please keep it turned off while you're in the courtroom and during jury deliberations. An electronic device includes any electronic storage device as well. As I told you last week, if somebody needs to get a hold of you during the course of the trial, they can call the courtroom and we will deliver any emergency message to you right away. You can certainly check your phones at the recess and at lunch as well. During the course of the trial, it may be necessary for the court and counsel to meet outside the presence of the jury, either back in my chambers or out in the hallway, or sometimes I'll ask you to leave the courtroom and we'll have a discussion outside your presence while you're outside the courtroom. You should not speculate on these proceedings because they concern legal issues upon which the court must rule before the trial may proceed. Now, during the trial, you may meet the attorneys or other witnesses in the hallways or in the elevators. Again, please not think they're being unfriendly when they do not speak to you. All these attorneys are very, very nice people, but if you go up and try to talk to them, they're going to be a little bit rude and tell you that they can't talk to you. It's by order of the court. You are directed to have no conversation of any kind with any party, attorney, witness in this case during the course of the trial. Likewise, the attorneys, parties, and witnesses are also directed not to speak to any juror during the course of the trial. Do not listen to anyone who tries to talk to you about the case or about any of the people or subjects involved in it. Again, if someone asks you about the case or about which case you were sitting on as a juror, just tell them that you cannot discuss the case. If that person keeps talking to you about the case, you must end the conversation immediately. When the trial has ended and you have been released as jurors, you may discuss the case with anyone you want, but that's at the end of the trial, and I will let you know when that happens. Under California law, I'm required to advise you and instruct you that you must wait at least 90 days before negotiating or agreeing to accept any payment for information about this case. If you receive any information about this case from any source outside of the trial, even if it's unintentional, do not share that information with any other juror. If you do receive such information, or if any person attempts to improperly influence you or any member of the jury, you must report such attempt immediately to the court. Just write a note out to Manny, and Manny will deliver it to me immediately. Counsel, I can instruct you to have your witnesses not converse anywhere where the jurors may overhear them. And for the jurors, I'm going to ask you always wear your juror badge, especially in a hallway here, because that way potential witnesses will know that you're a juror on the case and they won't discuss the case near you. Also, you need to wear your juror badge when you go out to lunch, because there may be jurors who might be, witnesses who might be having lunch nearby, and if they see that you're a juror on the case, they can move to another table. That way they can identify you and make sure that they don't discuss anything that you shouldn't be hearing. Do not let bias, sympathy, or prejudice or public opinion influence your decision in any way. And finally, you must reach your verdict without any consideration whatsoever of punishment. I went through the trial schedule with you last week, and I gave you the trial schedule that you could take home with you. Again, you need to be available to serve until June 21st. On a normal day, we will go till 12 o'clock and take a 15-minute break in between that time. We'll start up again at 1:30 and go to 4:30 with a 15-minute break in between. The breaks are not only for your benefit, they're also for the benefit of the court reporter, who gets quite a workout transcribing or reporting everything that happens here. All right? So with that said, it is now time for the attorneys to give their opening statements if they so desire. They will outline what they expect the evidence will show in this trial. Please remember, what the attorneys say is not evidence. That's not to say what they're about to tell you is not helpful to your understanding of the facts. So that said, are the people ready to give their opening? Yeah. All right, go ahead whenever you're ready.
Thank you. Kellen Winslow is a man who has been given much. He reached the top heights of his profession. He reportedly has earned over $40 million himself as a football player. He was born the son of a man who himself had achieved great heights in his profession. Mr. Winslow, the defendant in this case, has been given much, but it was not enough. You will learn over the course of the next few weeks that Kellen Winslow took what he wanted. He took what he wanted, not from one, not from two, but 3 women. He victimized 5 women. 5 separate women who knew nothing of each other, who had never met one another, who were either complete and total strangers to Kellen Winslow, or who had only recently met him and had fleeting interactions with him. Over the course of this trial, you will hear from each one of those 5 women, and you will see what this defendant took. It wasn't enough for Mr. Winslow to be given what he had in life. Instead, he took from these women. This is the defendant in court. You see him before you today, and he's been in court for numerous pretrial hearings. So have multiple victims. You will hear about prior testimony. You will hear about prior statements. And ultimately, at the end of this case, I am confident that you will decide this defendant's guilt for each and every one of the charges. Kellen Winslow on the left in his DMV photograph, Kellen Winslow in the middle when he was contacted by police, and Kellen Winslow on the right when he had been arrested and brought to justice. The same man who sits before you today, and the same man who committed these crimes against these 5 separate women. This is Kellen Winslow in June of 2018. As you can see in the center, the left and the right, that is the Kellen Winslow that was out on the streets of Encinitas committing his crimes. As you can see, the extensive tattooing on his left arm and on his right arm. Ladies and gentlemen, you will learn over the course of this case that this is not a question of whether or not he was the person involved in these crimes, but rather what the crimes are. And I submit to you that the crimes that have been brought in this case, as it relates to Jane Doe 1, are kidnapped for rape and oral copulation, rape by force or fear, and oral copulation by force or fear. That's one of the first bits of information that you heard about when you were first brought to court. When you were prospective jurors, now you've been sworn in and paneled and will be the ones who will be deciding this case. Jane Doe 2, counts 4 and 5, are rape by force or fear and sodomy by force or fear. And I'm going to give you an overview of the evidence as it relates to both Jane Doe 1 and Jane Doe 2 and what they have said this defendant did to them. You're also going to hear about Jane Doe 3. In May of last year, a neighbor to Mr. Winslow, unknown to this victim, but a woman who again had something taken from her, when the defendant decided that he wanted to target her, just as he had targeted Jane Doe 1 and targeted Jane Doe 2 in the weeks and months before. And that he exposed himself to her as she cried out for her husband. You're going to hear about Jane Doe 4. Jane Doe 4, as you've heard already, is a 17-year-old girl who's now grown, married, a mother, 15 years removed from what had happened to her when she was still a child, 15 years removed from what the defendant had done to her when he was 19. Well, you will hear about the way in which Mr. Winslow raped her back in 2003. You will likewise hear from Jane Doe 5. Jane Doe 5 is a 77-year-old woman who, while engaged in her regular routine of going to the gym with her husband in Carlsbad at a Crunch Fitness near Palomar Airport Road off of El Camino Real, where this defendant, this man on trial, this man sitting in court before you, touched his own penis, stroked his own penis, rubbed his own penis, and asked her if she liked it. Asked her if she could see it as he stood before her. You will hear that that wasn't the one and only time she had an interaction with this defendant, but that weeks later, he again got into a hot tub next to her with nothing but a towel on, and he masturbated next to her. A 77-year-old woman. Again, 5 women, unknown to each other, barely known to the defendant. All of them have come forward to tell you about his deeds. And I ask you to judge him by his deeds, not who he is, and not who his father is. Jane Doe's 1 and 2. Jane Doe 1 on the left, Jane Doe 2 on the right. Jane Doe 3. Jane Doe 5. This defendant took from each of them. And here is Jane Doe 4. As you can see, pictured with Jane Doe 4, our 17-year-old victim, is undoubtedly Kellen Winslow. Again, it's not a question whether or not he's the person who committed these crimes. You're going to hear from Jane Doe 4, and she's going to tell you why she retained that photograph. She's going to tell you why she kept it. And she's going to tell you that the reason why she kept it was because she wanted something to remember. Something to remember and remind herself that anything can happen to you, even when you feel safe. That the worst of things can happen to you, despite any protections you may think you have. So let's start with Jane Doe 1. On St. Patrick's Day, on March 17th of last year, 2018, she stated that she was hitchhiking on Santa Fe Drive near Lake Drive, that she lives with a family member in the area, but she's frequently on the streets. That while she was walking that late afternoon and asking for a ride from anyone who would pass by, she walked westbound on Santa Fe near Lake Drive. Lake Drive is going to be a particularly important location in the city of Encinitas. In fact, Mr. Winslow himself lives at 1310 Lake Drive. You're going to hear that what she described as a black square-shaped Jeep with a hard top pulled up alongside of her. She was thumbing a ride, and she saw a driver who, at least initially, appeared to be nice. She was not intimidated by him. She described him as being half black, half Caucasian. He had short and curly hair. He was muscular, and he had tattoos on both of his arms, extending from his wrists up to his shoulders. Certainly consistent with the description of Mr. Winslow as you've seen from the photographs. And initially, when she got into the car, she just asked for a short ride down to coastal Encinitas, where she would go shopping on Coast Highway. She said she was tired from walking and she just didn't want to walk anymore, so she asked for a ride. As she got into Mr. Winslow's vehicle, that they began to have friendly and small talk, that they were just talking about what are your plans for St. Patrick's Day. You're going to hear that on that same day, as they began to ride down the road on Santa Fe, they had began to pass San Diego High School, the academy that's right there. That as they passed the high school, she noticed that the defendant's demeanor changed, and she became concerned for her safety. Yes, she had just gotten into a car with a stranger. She'd never seen the person before. She was thumbing a ride. She thought she'd be okay. She never would have expected what happened to her. That as the defendant's attitude changed, he then told her, "I'm going to fuck you, and if you say anything, I will kill you." This defendant's own words. You'll hear her describe as she continued down westbound on Santa Fe, that after the defendant had said that, it was as he was passing the 7-Eleven that's there on the northwest corner, right as you approach the 5 freeway. And you're going to hear that she began to protest with him, plead with him. Pull over right here. Don't take me over there. She begged him, let me out right here, as they passed the hospital, Scripps Hospital in Encinitas, and went under the freeway overpass. That the defendant then made a left-hand turn to drive into a shopping center where there's a Vons and a 24-hour fitness. That becomes important in this case. He drove to the rear of that shopping center, alongside the freeway, and as he parked the car, he repeatedly said to her, "I'm going to fuck you." She was scared. She was afraid. She's going to tell you that the defendant told her, "If you don't do whatever I want you to, I'm going to kill you right here. I don't care who's going to watch. I'm going to kill you." She said she was too afraid to scream. She knew that she was going to die. She was afraid. You're going to hear from Jane Doe 1 that this is the location where she was taken. As you can see, it's the rear side of a parking lot from the vantage point alongside the 5 freeway. And you can see that there's some dirt along the side of that parking lot, that there's some ice plant that's there, and it slopes upwards towards the 5 freeway southbound on-ramp. You're going to hear that when she got there, the defendant stopped his car. He had threatened her. He had instilled fear in her. She believed she was going to die. She was afraid that this man who she had never met before, after he had made these threats, had either a knife or a gun, and that he was going to use it. So she complied. She was in survival mode. She did what he told her to do. A man much larger, much stronger, much more imposing than she could ever hope to be. She'll tell you, "I can't tell you why I didn't run. I can't tell you why I didn't scream. I was that scared." But she remembers thinking she did not want to die. So she listened and did what defendant told her to do. He told her to get out of the car. he told her to go over the fence, go over to that dirt side near the freeway. And once they had gotten over the fence, over along that ice plant that I showed you, that the defendant told her to take her clothes off. She began to remove her pants. She was scared. She said that she could see cars driving by on the freeway, and she even had that moment, that thought, that he was going to throw her into the freeway when he was done with her. And then she's going to tell you that he changed his mind. She doesn't know if he saw something, saw someone, or that someone saw them, that he changed his mind and he told her to get back in the car. So she did. She followed his instructions because she was scared. She got back into his SUV, back over the fence, as you can see here, and into that parking lot. And that when she got into the front passenger seat of the defendant's car, he then told her, she began to plead again, I won't say anything if you just let me go right now. Nobody will ever know. Again, she was in survival. Defendant said, no, I'll fucking kill you. I'm going to fuck you right here. And he removed what he was wearing, what she described as workout spandex, or what wrestlers would wear, that extends up over his shoulders all the way down to his thighs. And he exposed his penis. And she's going to describe it in detail. He was erect, he was large, and he told her to perform oral sex on him. And she's going to tell you that she did, that she was afraid of what would happen if she did. You're going to hear that after what she estimated to be about 2 minutes or so of performing oral sex on him, she couldn't really do that. Physically, she was unable to do that. And that the defendant then pinned her down, crawled on top of her as she sat in the front passenger seat, hurt her with the weight of his legs, placed his foot on her thigh, pinned her down to where she could feel the pain of the pressure of the weight of his body, and then he raped her. That he raped her vaginally.